Hi everyone, today I wanted to discuss with you the new notification that has been passed by the Ministry of Home Affairs under the Disaster Management Act, which clearly states that all the employers are under an obligation to pay the entire remuneration to the employees during which this entire lockdown is going to continue because of the COVID-19. So there are two important questions that have emerged out of this. The first being that are employers under an obligation to pay the entire remuneration to the employees? And secondly, are you even in a position as an employer to terminate the services of the employee again during which this lockdown continues? So we're going to be discussing these points today after and when we focus on all the labor law regulations that are applicable in India presently. So stick around, we're going to nosedive into this in depth. The government notification only makes a reference to any industry or shops or commercial establishments, and it makes a reference to wages and workmen, and nothing has been defined in that notification. So, who are these workmen, and do they even fall within the definition of a wages, and who are these other establishments that we're speaking of? So, in order to come to understand this very clearly, we need to rely on the Indian labor law regulations, and there are four of them which are the most critical ones. The first being the Payment of Wages Act, then is the Industrial Disputes Act, then is the Factories Act, and then is the Shops and Commercials Establishment Act. So let us evaluate all of these acts separately to understand whether an employee falls within any of these categories or not. So the Payment of Wages Act governs all the wages that are to be paid to the eligible employees under the Act. So we need to focus on two things in order to understand whether the employees are even eligible to receive the compensation from the employer or not. The first one is the definition of what is wages, and secondly, what is the category of employees that we are speaking of. So the definition of wages is very comprehensively defined under the Act, but just to sum it up, it includes all kind of remuneration, either in the form of full entire compensation, the bonus, the travel allowance, any contribution that the employer needs to make towards the employee provident fund. Now coming to the second aspect, which is the who are the employees that we're talking about. So the Payment of Wages Act makes a reference to all employees in the industrial and commercial establishments, but it does not include people who are in the supervisory, technical, or in an administrative job. And secondly, and most importantly, it does not cover employees who are earning wages of more than 24,000 rupees per month. So therefore, the Payment of Wages Act only requires the wages to be paid to those employees who are earning less than 24,000 rupees per month. Under the Industrial Disputes Act, all wages are to be paid to the workmen who are performing any activity in the form of skilled, unskilled, clerical, technical job that is involved, but it does not include people in the managerial and supervisory capacity. Further, it does not include any class of employees who are earning more than 10,000 rupees a month. Another important legislation to focus on is the Shops and Establishments Act. The Shops and Establishment Act is a very state-specific subject, and every state has its own act in this regard. But the most of the Shops and Establishment Acts cover the fact that the compensation only needs to be paid to those employees who are falling under the Payment of Wages Act. And as we discussed earlier, the Payment of Wages Act only covers employees who are earning less than 24,000 rupees a month. And therefore, people who are earning more than 24,000 rupees a month will not need to be paid compensation by any establishment that they are employed by. So after examining the labor law regulations in India, it is quite clear to understand that unless you don't fall in the three categories that I will speak of now, you're not required to pay any wages to your employee. The first being that you are either in a managerial or a supervisory capacity. The second being that you are earning 10,000 rupees or less a month under the Industrial Disputes Act, and the third being that you're earning less than 24,000 rupees a month under the Payment of Wages Act. Of course, if you fall outside of any of these three categories that I've discussed, then you will be required to pay wages to your employee, regardless of the industry that you are a part of. So now, since we have spoken of who are the eligible employees who are entitled to receive compensation from their employers, based on the Indian labor law regulations. Now let us speak about who are the employees and whether their services can be terminated or not. So this falls into two categories. One is the employees who are earning wages. So let us take up that first. So the employees who are earning wages based on the Indian labor law regulations and who are entitled to receive it, their services cannot be terminated unless there is a clause in the agreement which still entitles the employer to terminate it. But even if that happens, I think the employee can obviously question it or raise an objection or take it up with the labor commissioner. So the interpretation of that is going to be quite dicey, actually. But per se, based on the MHA order that has been passed by the government, it is not possible to terminate the services of an employee who's earning wages. Now let us take the case of an employee who's not earning wages based on the definitions and based on the other labor law regulations that we have discussed. If they don't qualify as receiving wages or they don't even qualify as workmen, then you are free to terminate their services, and this will completely depend upon the employment agreement that you have with the concerned employee. However, that employment agreement should give you the right to terminate the services, and it should not be a unilateral right. As long as you're given a prior intimation and you have the ability to terminate the services of that employee who does not earn wages, then you're free to do so. I want to share a case study with you right now. So this was approximately a week back. I had a startup client who reached out to me because he wanted to terminate the services of a few employees. And he reached out to me for some advice based on the employment agreement that he had with the employee. And purely based on that agreement and the other Indian labor law regulations in force, I advised him that he was free to go ahead and terminate the services. Now, he terminated the services of the employee, but what that employee did was he actually reached out to the COVID helpline and he complained about the employer. And if I'm not wrong, there was a government official who got in touch with this founder from the startup, and he told him that strictest of action will be taken against his company if he still terminates the services of an employee, and he should continue to keep paying wages to the employee on compassionate grounds and even on a humanitarian basis. So if you ever land up in a scenario like that, as a company and as an employer, you have one remedy available to you. What you can do is that you can still pay that employee that wage, but you need to pay it under protest. And you clearly need to say that I am paying you those wages today with the ability to recover that amount from you in the near future. You need to create appropriate documentation in this regard, and you need to obviously issue a letter to the employee informing him of this entire situation and how you have the ability to recover this due from the employee in the future. I just wanted to share this practical tip with you. And if you ever land up in this situation, then you have this legal remedy that's available to you. Thanks a lot.